Welcome everyone to CILA's webinar, Overcoming Analysis Paralysis, Practical Considerations for Adjusting Status Based on SIJS. My name is Dalia Castillo-Granados, and I'm the Director of the Children's Immigration Law Academy, or CILA. With me on the webinar is Vicky Giambra, Senior Staff Attorney at CILA. If you have any questions throughout the webinar, please type those into the Q&A box. We will answer questions throughout the presentation. The PowerPoint and handouts for this webinar will be emailed after the presentation today. We are recording the webinar and it will be available on our website, www.cilacademy.org, within a couple of weeks. If you would like Texas CLE credit or a letter of attendance, please complete the CLE webinar at the end of the webinar. CLE survey at the end of the webinar. CILA is a project of the American Bar Association's Commission on Immigration. We do not serve clients directly. Instead, CILA's mission is to increase the capacity of attorneys and legal service providers to ensure that children have legal representation when facing deportation. CILA is located in Houston, Texas, and focuses exclusively on children's immigration matters. In Texas, we provide training and education, case and issue-specific technical assistance to advocates, and coordination of working groups for practitioners to connect and learn from each other. We also work to build the capacity of pro bono programs nationwide and host a platform for legal service providers called Pro Bono Matters for Children Facing Deportation. Today's webinar will go through the practicalities of adjusting status to lawful permanent resident based on special immigrant juvenile status. SIJ classification is categorized as an immigrant visa that is subject to numerical limitations that are outlined by statute. A client who is granted SIJ status is eligible to apply for LPR status once a visa number is available and they meet the other eligibility requirements for permanent residence. We'll start with the basics, discuss jurisdictional issues, adjusting status before the immigration court, adjusting status before USCIS, common inadmissibility issues, and the use of discretion to adjudicate these applications. We named today's webinar Overcoming Analysis Paralysis because we realize that many SIJ clients are in removal proceedings, which complicates the process for adjustment. Sometimes it's hard to figure out the right path to take, given shifts in practice, whether local or national, the almost impossible task of trying to figure out the timeline for adjudication because of changing priorities or COVID closures, or because a complicating issue may arise in the case. What we hope to avoid is being paralyzed by indecision because of all of the moving parts. We hope this webinar gives you the tools you need to consider all the options, make a plan, and follow it through until your SIJ client is a permanent resident. Before we start today's presentation, we're going to stop here and do a quick poll. The question is, have you represented a client for an adjustment of status through completion? It looks like most people have answered, so I'll close the poll now and share the results. So it looks like most people have not represented a client for SIJ adjustment, but they're in the process now. It looks like a good portion of you have represented a client before USCIS, less before the immigration court, and some before both. So we're going to start with a a hypothetical, the case of Yesenia. And we're going to be using this hypothetical case of Yesenia. Yesenia traveled from Honduras to the United States to escape abuse from her mother. Her father was not in her life. Upon being apprehended at the border, Yesenia is designated an unaccompanied child. She is put in removal proceedings. After a couple of months in detention, Yesenia is released to her aunt in Fort Bend County in Texas. Yesenia is able to find an attorney, and the attorney represents her aunt in obtaining a custody order from a family court in Texas that includes all of the required SIJ determinations. The attorney then files the I-360 petition, and the SIJ petition is approved, and Yesenia's next master calendar hearing is only a few months away. So starting with the basics, we're going to look at the statute and the regulations. And the statute for SIJ adjustment can be found at 8 U.S. Code Section 1255H. So that's at INA 245H. And the regulations, which are the rules that interpret how a federal law will be implemented, can be found at Title 8 of the Code of Federal Regulations, 245.1E3 for USCIS, and Section 1245.1E3 for EOIR. So looking at INA 245H, 245H allows special immigrant juveniles to adjust their status because they are deemed paroled for purposes of 245A, which is the adjustment of status provision. 245A says that the status of an applicant who is inspected and admitted or paroled into the United States may be adjusted after a grant of discretion to that of a person lawfully admitted for permanent residence if three things. First, the person makes an application for adjustment. Second, they're eligible for an immigrant visa and admissible to the United States for permanent residence. And three, an immigrant visa is immediately available to the applicant at the time the application is filed. 245H also lists the grounds of inadmissibility that are automatically waived or that are waivable under this provision. It also includes a list of grounds that are not waivable under this provision, but they may be waivable under a different provision of the INA. 245H also has the SIJ specific waiver for certain grounds of inadmissibility, which is broader and very, very favorable for SIJs. This waiver can be filed on Form I-601. And finally, it makes clear that for this waiver, the relationship between the applicant and the applicant's natural parents or prior adoptive parents cannot be considered as a factor in the discretionary waiver determination. So now looking at the regulations that can be found, the USCIS regulations can be found at 8 CFR 245.1E3. And just to note that the regulations are outdated. They don't take into account the changes that came from the TVPRA of 2008. And so they don't list out all of the admissibility grounds that can be waived or are waived under the under 245H. However, it's still important to take a look at, and it has some important information. It makes clear that SIJ applicants are paroled for purposes of adjustment regardless of their entry. It also finds that SIJ applicants are not barred from adjustment based on unauthorized employment, which is normally a bar to adjustment that's found at INA 245C2. And as I mentioned below, the full list of exempted grounds for inadmissibility are not listed here, but the SIJ specific waiver is included. Special immigrants are under the fourth preference employment-based category, EB4, which allocates about 7.1% of the 140,000 visas that are available for employment-based categories. So for special immigrants, there's about 9,940 visas available every year. And then there's also a 7% per country limit. So for the SIJ classification, or for the special immigrant classification, this means that each country is allocated about 700 visas every year. There is some flexibility in the statute to allow for additional visas if there are unused visas in other categories. We have the numbers from fiscal year 2019 in terms of how many visas were issued for special immigrant juveniles, and the per country limit that year was 705, but it was exceeded by several countries because of otherwise unused numbers. So those countries were El Salvador, Honduras, Guatemala, and Mexico. For that year, special immigrant juvenile cases averaged over 50% of the entire EB4 limit. So came out to a little over 5,000 visas that were issued that year. In 2020, we saw rapid forward movement, likely because of the closures of overseas consulates to process other EB4 categories, which freed up the special immigrant categories. We do have some backlog countries, so those are from applicants from El Salvador, Guatemala, Honduras, and Mexico. One thing to note is that the availability of immigrant visas doesn't necessarily keep pace with the amount of SIJ petitions filed. So the visa bulletin should not be used to guess how long it will be before an immigrant visa is available. As I said, about 5,000 visas are granted every year, but there has been a dramatic increase in the amount of SIJ petitions filed. So about 50,000 visas have been filed since 2018. Since there's no limit to how many SIJ petitions are filed each year, the visa bulletin is not an accurate measure of when a visa will become available. Another really great guide is agency guidance, and this comes from the USCIS policy manual. It has a lot of really good substantive information, so even if you have to proceed before the immigration court, it's a great place to start. It goes over the purpose and background of the SIJ classification. It has a full list of all of the statutes, regulations, and even bills that introduce legislation for SIJ. It lists out all of the eligibility requirements for adjustment, and those are that the applicant has to be inspected and admitted, or inspected and paroled, and we know that SIJs are deemed parole for purposes of adjustment. They have to be physically present in the US, which is a requirement under 245A. They have to be eligible to receive an immigrant visa, so they have to remain classified as an SIJ. We saw previously that USCIS was issuing requests for evidence to show that the child was still under the jurisdiction of the state court. We know that many children age out of the state court's jurisdiction, but many attorneys still had to respond to that notice, and it's because USCIS must look to see if the applicant remains eligible. There's also revocation provisions. So there's two types of revocation: upon notice for good and sufficient cause, and there's also automatic revocation provisions. The three automatic revocation provisions for SIJ are if the applicant gets married, then their I-360 would be automatically revoked, or if a state court finds that reunification is viable with the child's parents, or if there's a reversal of the best interest determination by a state court. An immigrant visa has to be immediately available. SIJs are subject to some bars to adjustment. For example, they're still subject to a terrorist-related bar, but like we talked about, they're not going to be subject to the unauthorized employment bar to adjustment. The applicant has to be admissible or eligible for a waiver of admissibility, and they have to merit a favorable exercise of discretion. And then finally, it goes through adjudication. So for USCIS, it does say that generally an interview will not be required, but if it is, then it will be child-friendly, and the child can also bring a trusted adult to the interview. It goes over the age out protections, which are outlined in the TVPRA, which is that only the I-360 must be filed before they turn 21. The adjustment of status application can be filed at any time. And then finally, the process for either approval or denial of the application. There's also guidance from UIR, and this comes from the Immigration Court Practice Manual and the UIR Policy Manual. And this chapter 3 is specific to filings with Immigration Court. So it goes over the delivery and receipt of filings, including guidelines for deadlines for submission. If the judge doesn't give a deadline for submitting the application, then it is 30 days before the merits hearing. Also, if you need to file a motion for extension or a motion to submit an untimely filing, it has guidance for those. Of course, when you submit an application with the court, you also have to serve the opposing party, which is ICE counsel. And the order, there's a chapter on document submission. So the order of the documents, and also specific requirements about filings from pagination to tabs to page numberings. And there's also a section on filing fees. UIR doesn't collect filing fees, so those have to be filed with DHS. And it goes over also the requirements for a fee waiver. And now I'm going to turn it over to Vicki to give a few tips on filling out the I-45.
Hi, everyone. I just wanted to go over some of the generic or more common questions on the I-485. First thing I want you all to know, previously we've heard about some asylum applications and U visa applications, and even some I-360s being rejected for blank spaces. This is known as USCIS's blank space policy. Well, thanks to one of CILA's partners, NILA, National Immigration Litigation Alliance, they helped to file Bangala v. USCIS. And the court has said that USCIS may no longer reject applications for blank spaces. So you don't have to worry about putting NA or none in every single blank on the application right now. Here are some other questions I just want everybody to look out for when you are going through them with your clients. So they pay special attention to question 22, which is how the client arrived in the United States. Generally, I would say most clients are usually under the came into the United States without admission or parole. But pay attention and look through your file and make sure you know exactly how the child arrived in the United States. Your child's current immigration status is actually special immigrant juvenile status because they have been granted that status by USCIS, even though it hasn't given them an immigrant visa yet. And then they are also filing this form as the principal applicant. So that's the first question of part 2. Going on in part 2, in order to do the adjustment under SIJ, you are going to choose 4B, that you are adjusting, your client is adjusting for special immigrant juvenile form I-360. And then one other note here, I get some questions about this. Not everybody is familiar with what 245I is. And there is a specific question that asks if you are adjusting based on INA 245I, and the answer should always be no. That is not something that is applies to special juvenile status. It's complicated, so I'm not going to explain it right now. So the other thing to remember to do is in number 12 and 13, and that is to put in your receipt number, which came with the I-360. So on the I-797 that you got for the I-360, put the receipt number and the priority date from that I-360 receipt. One other thing, Dahlia had mentioned that you must still be under the jurisdiction of the state court, and you must still be eligible eligible to receive SIJ status when you apply for adjustment. And so watch out for this. Make sure that your clients don't get married, but if they have been married, even if they are now divorced or the marriage was annulled, the I-360 is immediately revoked upon marriage automatically. And so you will have some problems if you check anything other than single, never married, and you might need to refile, or you can refile an I-360 as long as the client is still under the age of 21.
Thanks, Vicki. So today we're focused on a specific population of SIJ eligible clients, and those are unaccompanied children. So most unaccompanied children are fighting against deportation. SIJ status and asylum are the most common forms of relief for children who have been designated unaccompanied. And many of our SIJ clients are going to be eligible or able to adjust their status before USCIS or EIR, depending on the procedural posture of the case. So generally, applicants are either applying for relief affirmatively or defensively. And this is a term that's most often used in asylum cases, but it can also be used to describe the procedural posture for adjustment applications as well. So the first step is to determine the case posture. Will your client be applying for adjustment affirmatively or defensively? Since most unaccompanied children are in removal proceedings, they would typically apply for adjustment as a defense to removal. So why is this the case? Well, federal regulations lay out when an applicant for adjustment can apply before USCIS versus the immigration court. So 8 CFR 245.2A1 says that USCIS has jurisdiction to adjudicate an application for adjustment of status filed by an applicant unless the immigration judge has jurisdiction to adjudicate the application. And then we take a look at the regulations for EIR, and at 1245.2A1, it states that in the case of an applicant who has been placed in deportation or removal proceedings other than an arriving alien, then the immigration judge has exclusive jurisdiction to adjudicate the application for adjustment of status. So before we talk about the likely options for unaccompanied children, there are a lucky few who may be able to apply for SIJ status and adjustment concurrently before USCIS. So if the client is not in removal proceedings, or they are an arriving alien and they're not from a backlog country, so the priority date is current, then the SIJ petition and the adjustment of status application can be filed together before USCIS. The benefit, of course, is that the process will be much faster and the client can get employment authorization while they wait for adjudication of the filings. For most unaccompanied children, however, it will likely be a two-step process. So if the client was never in removal proceedings, either because they have they've never had contact with immigration officials, or because the NTA has never been filed with the immigration court, or because they're an arriving alien and they're from a backlog country, then they would do the adjudication in two steps before USCIS. If the client is in removal proceedings but is able to get their case dismissed or their case is terminated, then they would be able to apply with USCIS after the I-360 is approved. Or if they remain in immigration removal proceedings, then they would also do two steps. The I-360, of course, with USCIS, and then the adjustment of status application with the immigration court. So to allow for adjustment before USCIS, the charges have to be dismissed against the client. There are regulations that allow ICE counsel to move to dismiss the matter if circumstances of the case have changed after the notice to appear was issued to such an extent that continuation is no longer in the best interest of the government. matter of SOG and FDB finds that respondents can request DHS to file an unopposed motion to dismiss, and it cites to the EOIR regulations, which allow for this motion to dismiss. And finally, their ICE they are not required, but they are encouraged to exercise prosecutorial discretion to dismiss adjustment of status cases. This comes from a memo, an ICE memo from 2005. So basically, if ICE can join or file a motion to dismiss proceedings, the applicant has to show a prima facie eligibility for adjustment. They have to also support a discretionary determination for adjustment. And the memo also states that there should not be an asylum application pending. Of course, there's always complicating issues. And so one of the hardest things to overcome is not being able to discuss the case with ICE. They might be with ICE counsel. They might be hard to reach, or their local practice doesn't encourage them to exercise prosecutorial discretion. So that could be a barrier in the case. At CILA, we always recommend persistence. And so if the ICE counsel doesn't pick up your first 5 calls, perhaps they'll pick up your 6th call. But really, it's just a matter of reaching out so that you can figure out, what their preference is, whether they are allowed to exercise prosecutorial discretion, and what their preference is on filing the motion. Maybe they'll file the motion themselves, or perhaps they will ask you to file the motion, an unopposed motion, or they'll let the immigration court know that they're unopposed. But this is something that should be negotiated upfront with ICE before doing anything in the court. Another issue that can come up is perhaps you filed the adjustment application with USCIS already before the removal proceedings were dismissed or terminated. And so you might be trying to figure out what the next step is. USCIS will usually administratively close an application if the client is still in removal proceedings. So maybe you can get that motion to dismiss and then file the order with USCIS along with your motion to reopen the administratively closed application. Or maybe you're not able to get the case dismissed in immigration court, so you're going to have to move forward with EOIR. So trying to figure out whether it's possible to transfer the application from USCIS to EOIR, which is possible, but cumbersome. And so maybe you'll start over with a new application for adjustment with the immigration court. As we noticed, the 2005 memo does state that there should be no other application pending. And for most of our clients, there will be more than one application for relief, probably the potential for SIJ adjustment, but also an asylum application was filed. And so you should discuss with ICE what their position is on the pending asylum application. It can feel uncomfortable to decide to withdraw that asylum application before you get your adjustment adjudicated. And so that might be a consideration in the case. And then finally, perhaps your client was once in removal proceedings, but they have since received an order of removal. If they did not attend their immigration court hearing and obtained an in absentia order, but that in absentia order hasn't been executed, then you would have to seek reopening the case before moving forward, either with the immigration court or USCIS. On the other hand, if your client was physically removed, if they took a voluntary departure or order of removal and were removed from the country and re-entered, then you might be able to seek a waiver for that ground of inadmissibility when you apply for adjustment. So making that final call is really just about weighing the different options. What are the viable options in your case? Is your client an arriving alien? If so, then they would have to move forward with USCIS. On the other hand, if ICE counsel refuses to dismiss the case, then that also limits your options. Another consideration is the timelines. With the COVID pandemic, it's unclear. Some courts are closed and it's unclear when they'll reopen. Also client preference. Your client might be traumatized and not want to be in an adversarial setting. So that's something also you should consider, although you can't make any promises about whether or not you'll be able to get the case out of removal proceedings. And then local practice. Does your ICE counsel, will your ICE counsel, move to dismiss the case, exercise prosecutorial discretion? And so the steps you should take, I'm a big fan of lists. You could list it out, map it out, figure out all of the different options, talk to your colleagues to figure out what their experience has been and what the local practice is in your area. And of course, talk to your client. This is a complicated issue, but kind of laying it out for your client and getting their preference is good, although you can't guarantee that one result or another will happen because there's just too many moving parts. So going back to Yesenia, you've spoken to Yesenia. She prefers a non-adversarial setting. And with USCIS, you know that an interview might not even be required, but you also consider the fact that going before USCIS will require coordination with ICE, which is really hard in your jurisdiction. On the other hand, you believe that the immigration court judge would be willing to give you a quick setting if you can let them know that it would be a short hearing since there's no issues that have come up in Yesenia's case. Another benefit is that you would be able to file the adjustment application immediately and get Yesenia an EAD, but you're concerned that COVID will prevent the court from reopening. So we are going to do our second poll and give you a chance to chime in on Yesenia's situation. So given what you know from the case, should Yesenia move forward with her SIJ adjustment before USCIS or UIR? Okay, it looks like about half of you have voted, so I'm going to end the polling and share the results. And it looks like most of you would prefer to go before USCIS. Okay, so we'll move on. We're actually going to start with immigration court. So in this scenario, Yesenia decides to move forward with immigration court. So we'll discuss what those next steps are. So even though the preference seemed to be to go before USCIS, going before the immigration court is not as scary as it seems. I've done several adjustments before the immigration court and only had one dramatic hearing where ICE counsel contested my client's adjustment, but otherwise it was a pretty, standard process. So here are the steps to ensure that you do have a smooth process. USCIS does have a webpage on immigration benefits and EIR removal proceedings, which links to the pre and post order instructions and other helpful information if your client has to seek relief before the immigration court. And of course, you're going to want to turn to the immigration court practice manual and perhaps dust off those trial advocacy skills to make sure your clients gets the best result. So the first step is to follow those pre-order instructions. You can obtain that form online, as I said, or you can get a copy from ICE counsel. You file a copy of the application, the fee or fee waiver, a mandatory $85 biometrics fee, a Form G28, and a copy of the instructions to the Texas Service Center. Now, if you have to file a waiver of inadmissibility, then you're going to use Form I-601, and you would follow the same procedures. It's another application, and so you can file it at the same time as your I-45 application. You see here that you either include a fee or fee waivers. So even before following the pre-order instructions, if you want to seek a fee waiver from the judge, then you would file a motion to waive fee. And there are some guidelines at the EIR policy manual. The fee waiver must be allowable by DHS, which it is for SIJ applicants. And the request for the fee waiver has to be accompanied either by a properly executed affidavit or an unsworn declaration, which substantiates the inability to pay the fee. So it does require some information about your client's situation and why they're unable to pay the fee. You will receive USCIS notices after filing with the Texas Service Center. So you'll get a receipt notice confirming that USCIS received the applications. And then secondly, you'll get a biometrics appointment notice. Here's a link for information from USCIS about how to prepare for your biometric service appointment. It has information about what to do if you need to change the appointment, and information for people who are in removal proceedings. Attorneys don't typically go with their client to the application support center, and the staff at the centers are used to seeing clients on their own. Usually the client will fill out a short form on their biographic information, and then the staff there will help them through doing a digital signature, taking their photograph, and also taking their fingerprints. Once you have that receipt notice, you should also consider filing the I-765 application for employment authorization, which you do directly with USCIS. And another form that adjustment applicants often file is the Form I-131 for the application for travel document. But if your client is in removal proceedings, then they should not file this application because they cannot travel outside the US while in removal proceedings. So the second step is to file the adjustment of status application with the immigration court. As I previously said, Chapter 3 of the Immigration Court Practice Manual deals exclusively with filings before the immigration court. So it does have a section on the order of the documents, the preferred order of the documents, which is filing the E-28 if you haven't already filed that, a cover page, the fee receipt, the application, any proposed exhibits, and proof of service. Now, some exhibits that you will submit with the application are things like the medical exam on Form I-693 and the photos and birth certificate, any other documents that are required by the application instructions. If your client has any criminal history, then the immigration court prefers that you file or recommends that you file a criminal history chart, but you don't have to. And if you are worried about a negative discretionary decision, then you might want to file proof of positive equities in the case. And Vicki will talk more about that later. So preparing for the merits hearing. The background check, it's really important to make sure that the background check is complete before going to your merits hearing. So first ensuring that your client actually attends their biometrics appointment, but then following up with ICE to confirm that the background check is complete. If it's been a while since your client got their fingerprint check and between that and the merits hearing, it's been a while, then the fingerprints might have expired. But there is an agreement between USCIS and ICE where non-detained cases where fingerprints will expire before a final decision by EOIR can be updated without the client needing to go in for a second fingerprint biometrics appointment. So you can find information about that on the USCIS website. If ICE can't update the fingerprint results, then they are supposed to reach out to USCIS, and USCIS will issue a new fingerprint appointment notice. So you'll see that all of this is ICE's responsibility, but of course you want to follow up and make sure that all of these steps are complete. In terms of preparing your client, it'll be important to review the documents and all of the exhibits that you submitted to the immigration court. You'll want to practice the direct examination questions, which are usually questions that go along with the I-45 application. And then if you, then you can also practice any cross-examination questions that you think might come up. So ICE has an opportunity to question your client, and you want to make sure that your client is prepared. And it's always best practice to have somebody else play the ICE attorney role. So maybe you can have a colleague come in and help you during this preparation and ask some questions of your client that might come up from ICE. And then of course you want to negotiate with the ICE Assistant Chief Counsel before the hearing, to understand what their position is on the application, and then whether they're willing to stipulate to a grant of adjustment, or perhaps they're willing to stipulate to not do cross-examination, which means that they might talk to you about making sure that all of their questions are answered, that you ask them on direct. This can be especially helpful if your client is very young, and it would be much better for your client to get all of the questions from you instead of also questions from ICE. So going to the merits hearing, we know that during the COVID pandemic, there might be the possibility of having remote hearings. So UIR has actually rolled out potential an online platform through WebEx to have hearings, or they could ask you to do a phone hearing as well. And it'll be important to make sure that you're addressing all concerns at the hearing itself. So if you think that you're, if you can't hear the ICE counsel, or if your client is having a hard time hearing the translator, then those are all things to address while on the record. The Operating Policies and Procedures Memorandum has issued UIR issued an OPPM, OPPM 2013, and it's UIR practices related to the COVID-19 outbreak. And in it, it says that parties are encouraged to resolve cases through written pleadings, stipulations, and joint motions, which can include a stipulated order granting protection or relief from removal. So, we don't have a lot of information about this, but you could try to figure out whether ICE is willing to join you in a stipulated grant to adjustment. And potentially this could even happen even if the immigration courts aren't open yet. Maybe they're willing to file something with the immigration court, or maybe they're willing to agree to allow the immigration judge to adjudicate the application without a hearing. I know this can feel uncomfortable, but it's not terribly different than allowing USCIS to adjudicate the application. you've submitted all of your evidence and you're allowing the judge to make a decision based on the papers. And then finally, I talked a little bit about a contested hearing, but that could happen. So that's when you want to really brush up on your trial advocacy skills. A reason for a contested hearing could be that ICE doesn't agree to a discretionary grant of adjustment. Perhaps your client has a juvenile delinquency issue that wouldn't make them inadmissible, but they believe it doesn't merit a grant of discretion for adjustment. That could be a contested issue, or perhaps you're arguing that something is not an inadmissibility ground, or perhaps they're opposed to granting the I-601 waiver for a ground of inadmissibility. So something to make sure you discuss with your client beforehand is what to do if the adjustment is not granted, what your options are for appeal. And finally, let's assume you do get a grant of adjustment. So then you would follow the post-order instructions, and those require that you call USCIS, attend an appointment there at USCIS, and submit a copy of the final order. And the reason for this is that USCIS is the one that produces the lawful permanent resident card. So you will have to work with them to make sure that your client gets their LPR card. And you might want to make a copy for the file just in case your client loses their card and has to seek another one. You also want to make sure to have a closing letter, give a full copy of the file to your client so they have a copy of everything, and give clear instructions for next steps, including how to obtain their Social Security card and whether they need to file register for selective service if they're a male between 18 and 25. And if they're a client under 14, then they will need to file an I-90 to replace their permanent resident card at age 14. And the reason for that is so that fingerprints can be taken in a background check complete, since that was not done. That is not usually done for kids under 14. And then another thing you might want to consider is officially withdrawing from representation. So obviously you need to talk to your client about this before you do it, but you can file a motion to withdraw after the final hearing. And this would make sure that you're not on the hook in case your client is put back in removal proceedings in the future. And with that, I will turn it over to Vicki.
Okay, so if we're in our choose your own adventure here, this is option 2. So Yesenia instead decides that she wants to submit her I-45 with USCIS. So Dahlia has already mentioned this, but before you can, adjudicate, have an application adjudicated for adjustment of status at USCIS, if you're in removal proceedings, you must get them dismissed. So like she said, contact OCC, Office of Chief Counsel, and see if you can get them to exercise their prosecutorial discretion and join a joint motion to dismiss. Show them that the priority date is current and that they, they have their discretionary reasons why they should be granted. And then, you'll submit it to the immigration court, and then the IJ will decide officially whether to dismiss it or not. Okay, so we'll continue on with our hypo for Yesenia, and we're adding a few more facts here. So you are filling out the I-45 with Yesenia. You request her ORR file previously, or you requested her ORR file previously, and upon reviewing it, notice that during a mental health evaluation, the clinician indicated that Yesenia may have been involved with a gang. When you ask Yesenia, she absolutely denies it. She left Honduras because a friend of hers was killed by the gang. When you ask her if she has ever been arrested or had any trouble with the police, at first she says no. But then she remembers that before she graduated high school, she got into a fight with another girl. The campus police got involved and someone mentioned assault, but she's not sure what happened. She also mentions that she was in a car with some friends who were smoking marijuana, but she did not join them in smoking. The driver got pulled over and the police took them all to the police station. She remembers her uncle came to pick her up and take her home, but not much else because it was very late and she was very tired. In passing, Yesenia also asks you if she needs to file taxes for the money she has earned at her job. So now is time for our third poll. Oops, wrong question, 1 second. Okay, so what issues do you think should be explored before you submit Yesenia's I-485? And this is multiple choice, so you can choose as many as you'd like. Okay, I would say about half of everybody who has voted, so I'm going to go ahead and end polling. And yes, I'm glad that every single one of these has answers. The most popular one was arrest records. And yes, all of these things should be looked at. So what are we getting at here with these hypo facts? Well, what we're looking at, is inadmissibility. So this is something that is laid out in INA section 212. These are the general categories that are inadmissibility grounds. In part 8 of the I-485, all those questions are aimed at inadmissibility and trying to find out inadmissibility grounds for the applicant. And in the I-485 form itself, they actually have headings that show you what area of inadmissibility they're looking for. So one of the first areas is health. Do they have a communicable disease or a physical or mental disorder? Criminal, obviously, a conviction for a crime involving moral turpitude or controlled substance, or vice issues like prostitution or commercialized vice. National security issues like terrorism, espionage, Nazi participation, or genocide. Economic and employment issues. Many people have probably heard about the public charge. They also have inadmissibility grounds for people that are doing jobs that require labor certifications. You have immigration related, such as unlawful presence, removal order, previous removal orders, misrepresentation. And then there's miscellaneous grounds, which include practicing polygamy, international child abduction, and unlawful voting. So the health-related grounds are usually taken care of by the medical exam, so they're not actually really mentioned on the 485. The criminal grounds can be found at questions 25 through 45. Security-related grounds are questions 46 through 60. Public charge is 61 through 62. Immigration-related questions are 14 through 24 and 63 through 73, and the miscellaneous questions are questions 74 through 80. So CILA has previously talked about 245H, and that it's kind of what allows people with special immigrant juvenile status to adjust their status. It also lists those grounds of inadmissibility that are actually inapplicable to people of SIJS. So even if they have these, it doesn't count against them. So those are public charge, needing a labor certification, being present without admission or parole, misrepresentation, which includes a false claim of citizenship, which is actually a really hard inadmissibility ground to get waived. Stowaways, so people that stowed away on a boat or a plane or whatever to come here. Lacking immigration documents, so when you show up at the border and you don't have a visa that allows you entry or things like that, that's called lacking immigration documents. And unlawful presence. INA 245H also lays out those inadmissibility grounds that cannot be waived at all. And those listed on this slide are those grounds that also have no other possible waiver under the INA. So that is the ground of inadmissibility for the controlled substance trafficker, for traffickers in persons, for money laundering, and then national security related inadmissibilities, with the exception of membership in the totalitarian party. That is waivable. And I know I'm throwing out a lot of different categories in the materials that we're sending out after the webinar. We have created a chart that includes all of these grounds of inadmissibility and which ones are inapplicable to SIJS, which ones are waivable and which ones are not waivable. So let's look back at our hypo. Yesenia remembers that in high school, she got into a fight with another girl. The campus police got involved and someone mentioned assault, but she's not sure what happened. And as a reminder, Yesenia lives in Texas. So hopefully when I was reading that sentence to you, or two sentences to you, this was kind of triggering some thoughts. You heard the word fight, you heard police, you heard assault, and hopefully that triggered you to start thinking about the criminal grounds of inadmissibility. Something like assault would be under INA 212A2A(i). What is required is that somebody has to have been convicted or admits to committing acts which constitute the essential elements of a crime involving moral turpitude. So there's a lot there, but one of the first things we need to look at is, what does convicted mean? So convicted means a formal judgment of guilt entered by a court, or admitted sufficient facts plus a restraint on their liberty was imposed. So one thing to notice is that juvenile delinquency is not a conviction for inadmissibility purposes. This is something that you definitely need to keep in mind. Many of our kids, obviously when we started working with them, were under the age of 18. So if they did get in trouble, they possibly would have been charged under delinquency grounds. So the other element to consider is, what is the crime involving moral turpitude? It's not actually defined. It's been said in one case, they said moral turpitude is conduct that is inherently base, vile, or depraved, and contrary to the accepted rules of morality and the duties owed to other persons. Matter of Silva Trevino, however, kind of made this a little bit more simple, and it is reprehensible conduct plus a culpable mental state. So there must be intent behind it. You can't have a reckless or less mens rea. So before I start in on this slide, I want everybody to notice the little warning sign on the arrow here. We're getting into an area that is referred to as crimmigration. It is a very complicated subject area. There are practitioners that make this their entire practice out of this. So we are not going into this deeply. It is a difficult area, and my goal here is for you to recognize some of the issues and recognize when you need to go and ask somebody else for help or confer with somebody else. So, but generally, to know if you have something to worry about when you find a criminal ground and whether or not you have this inadmissibility issue, you have to figure out if the crime involved is actually a crime involving moral turpitude. Like I said, it is not defined anywhere what actually is a crime involving moral turpitude. So courts have developed a method of analyzing these crimes called the categorical approach. It's not only used in immigration, it's also used in sentencing and things like that. And the first part of the categorical approach is to determine the generic offense. So there's usually a federal definition somewhere of the offense, like there is a federal definition of assault, there's a federal definition of burglary, things like that. And then you compare that federal version, that federal definition and statute, with the state statute of that crime. And you look at the elements and you say, do these definitions match? Do the elements match? Then there are two more kind of things that go along with it. And then is the statute divisible, which means does it list multiple separate crimes and can you divide them out? And then there's modified categorical approach, which allows the judge to look behind and look at the actual facts of the conviction, whereas normally under the categorical approach, you look at the minimum conduct that would allow for that conviction. So let's look at Yesenia's case with assault. So we've already looked under it and we know that it's INA 212A2A little I, big I, and it is not waivable under 245H. So is assault a crime involving moral turpitude in Texas? Well, interestingly enough, there is a case that came out of the Fifth Circuit recently that says no, assault is not a crime involving moral turpitude in Texas in most instances. And the reason being is that when you look at the Texas statute, it includes reckless or unintentional mens rea. So it's not, assault is not necessarily not necessarily a crime that involves intent, excuse me. So basically, because the Texas statute includes offensive touching, it's not included. Now, there are some things that go beyond and some other kinds of assault that you can get in Texas that do match the definition of assault, but basic assault does not match the federal definition. And then the other thing to look at is how old was Yesenia when this happened? You know, she was at school. I've worked with some kids who, if they're SIJ kids, maybe they've taken a couple years longer to finish school, so they might be over the age of 18, but she may not have been. She could have been under 18 when this happened. So if she was charged with assault, or if somebody did charge her, was she charged as an adult, or was she charged as a juvenile? Okay, this is another part of the hypo. Let's go back and revisit it. Yesenia also mentions that she was in a car with some friends who were smoking marijuana, but she didn't join them. The driver got pulled over and the police took them all to the police station. She remembers her uncle came to pick her up and take her home, but not much else. So, drug offenses are covered under the inadmissibility grounds in 212A2A little I, big double I. And they are also not waivable under 245H, except for, there is one exception under 245H. It says a single offense of simple possession of 30 grams or less of marijuana. So, you know, drug-related offenses, by and large, are not waived by the INA or 245H, except with this little exception for 30 grams or less of marijuana. Even if you did find out that it was less than 30 grams of marijuana, she would have to still have a waiver, but the waiver would be granted based on humanitarian purposes, family unity, or when it was otherwise in the public interest. So there's a lot of different questions here to ask. First of all, was she actually charged? What was she charged with? What about 212A2C, which is another inadmissibility ground for drug trafficking? What if they maybe decided to charge her with drug trafficking for some reason? That's a big problem. And then the other problem is that I have actually experienced here in Harris County and in Houston that the crime lab does not weigh marijuana in grams. They weigh it in ounces, and kind of the lowest level crime is 0 to 2 ounces. Well, 30 grams is actually less than 2 ounces. So you actually, I've had times where I've had to go to the crime lab and ask for an actual report from them as to how much marijuana was weighed, how much there was. So kind of different things you can get into when you start looking at these issues. So how does this affect kind of the practical aspects of filling out a 485? Well, like I said, the questions for criminal inadmissibility start in question 25. And they do require you to provide additional information if you mark yes to any of these questions. And you'll find that you will have to provide paperwork and all that kind of stuff. My recommendation is to read each question very carefully. Read it, parse it, know exactly what they are asking for. So a good example of that, is question 26. Have you ever committed a crime of any kind? Well, there's actually kind of a definition for crime. There's certain elements, and it has to have met certain elements. So kind of think about those things and think about whatever behavior there was, does it meet all these elements, for example, before you answer that question. And don't forget the delinquency. That delinquency is not a conviction. So on the question 27, where it asks if you ever pled guilty to or been convicted of a crime or offense, well, delinquencies are not convictions, and they're not really considered crimes in that way. They're delinquencies. So you don't necessarily have to choose yes on that question if it was a delinquency. So various things. I'm not going to tell you exactly how you answer each of these questions. A lot of the questions on the 485 are incredibly fact specific and really depend on your client. So there is no one right or wrong way to answer a question. You just really need to make sure that you've read it and understand what the question is actually asking for, and know that it's trying to get at a certain inadmissibility ground. So one thing that's come up under these past couple of hypos is that Yesenia doesn't remember what happened. And this happens with a lot of clients. They don't really know what happened. And so how do you do this? How do you find out about it? Well, sometimes you may have done a request for the A file to kind of find these kind of things. And you may even have done an OBIM FOIA to get the A file. And that will include some of the criminal history, because they do a fingerprint check for the OBIM FOIA. But oftentimes we don't have time. FOIAs are taking a very long time these days, especially the OBIM FOIAs. So my recommendation is to do an FBI fingerprint check, which is just a straight up goes to the FBI, doesn't necessarily go to USCIS. And that will get you, it will get you any time really that they've been arrested where there has been fingerprints taken. They normally, most jurisdictions provide all of their fingerprint collection to the FBI and federal database. So it should bring up that conviction, or not conviction, arrest. So at least you have a place to start. Another thing you need to try is going to get the various criminal records in the state. In Texas here, we have kind of a national statewide database that you can look at, and it does cost some money, but it's worth it. And then, or you can go to the various jurisdictions the person was in if you know exactly where they were when this happened. But my big recommendation is that you get all of the materials and you find out what you're actually dealing with. So one other thing you need to watch out for is that there are times when maybe whatever behavior didn't actually lead to an inadmissibility because it was delinquent behavior, or it didn't actually fit into CIMT, or there's the petty offense exception to CIMT. Well, what you then have to watch out for is that you've got this, they're not inadmissible, but suddenly by magic, it turns into conduct-based inadmissibility, because for things like marijuana, they can show that if you've done it within the past year, you're a current drug abuser or you're a drug addict, and that makes you inadmissible under the health grounds. Or there's certain things like if you have gotten multiple DUIs, they can say, well, you're a danger to yourself or others, and that is under the DUI, that is under the health grounds. So those are just some things to look out for. But even the health grounds are waivable, like we said, under 245H. So for the waivers, you will be filling out a form I-601 for any waiver you need, except for, any waiver is I-601 in the SIJS context. So for 245H, so anything that is allowed to be waived under 245H, you are just proving that the waiver should be granted for humanitarian purposes, family unity purposes, or when it is otherwise in the public interest. For 212H waiver, which would be for if somebody has more than one CIMT or other criminal things that are not drug trafficking and generally not drug related, then you would be going under the 212H waiver, which requires the applicant to show extreme hardship to a spouse, parent, or son or daughter. So that can be quite difficult for some of our SIJs to show because they are either, well, they can't be married, they possibly don't, their parents are possibly not here, and they may not have children yet. So, but it's something to consider and explore. So the last thing that we're going to look at is Yesenia's ORR file contains a mental health evaluation indicating that she may have been involved with a gang. So I hope when you hear gang, that raises alarm bells for you. It is problematic, but why is it problematic? Interestingly, it is not an admissibility ground. Membership in a gang itself is not an admissibility ground. Some of the behaviors that come along with being in a gang, learning weapons and using weapons against people, etc., are inadmissibility grounds. But being in a gang itself is not an admissibility ground. What it does go to is discretion. So adjustment of status in almost every case, there are some exceptions, is granted based on discretion. The adjudicator has the discretion whether or not to grant it. So what things are they looking for? Well, first, you have to meet all the eligibility requirements set out in the INA. Then they look at, they add the negative factors, and then they add the positive factors, and they see where the balance is, where's the scale. So the chart I've pasted here is from the USCIS policy manual, where there's a whole section that talks about discretion and how they do it. But as you can see, if you've met the eligibility requirements in order to get a positive grant or get a grant of adjustment, you need to have the positive factors outweigh the negative factors. So negative factors, they generally split them into these 5 categories. So negative factors would be an absence of family or community ties. Also immigration issues, so violations of status, any removal orders or any fraud or misrepresentation. Business, employment, and skills, so unemployment, unauthorized employment, and illegal sources of income can be negative factors. Criminal tendencies, lack of rehabilitation from any criminal tendencies, safety and or security threats, and failure to pay taxes or child support. Other indicators, and then any other indicators adversely reflecting the applicant's character or undesirability as an LPR of this country. So that's very broad, but you can kind of get an idea. Positive factors, one would be hardship to the applicant and any close relatives if their application is denied. Immigration status would be compliance with immigration laws, approved humanitarian petition. SIJS is humanitarian, so there, by the fact that they have a grant of SIJ, they have an approved humanitarian petition, so that is a point in their favor. If they have education, skills, certain training in the US, employment, history and type of employment can be a positive factor. Now, of course, That's hard with our SIJ kids because many of them do not have EADs and therefore cannot work lawfully. But it's saying that if you have worked, it's positive. So it's, I could say that cancels each other out. And then if you have no criminal record or have rehabilitation from that criminal background, cooperating with authorities, compliance with tax law, non-court ordered community service, and then an absence of any negative factors. So some examples of these, because that all sounds very abstract, would be religious involvement. So how do you show some of these positive things? So a letter from your pastor, priest, rabbi, or imam, or other congregation members showing your involvement, that you go to church every Sunday, or you go to prayers at the mosque at 3 o'clock every day. Or you can also get letters from your community member that they know the client and have very favorable things to say about the client. Maybe they, during this time of COVID, maybe they've been getting groceries for their neighbor who can't go out, things like that. From school, especially if they graduated from high school. A letter from a teacher they got along with really well, or maybe even their principal if they got along with the principal. Transcripts, evidence of any extracurricular activities from their coach, something like that. Family, letters from family members about the client caring for them or for others. So if your client has their own children, from the child's other parents about how well this person takes care of the child and their relationship and all that kind of stuff. The other thing that can be really, really important to show, especially if your client has some criminal issues, is rehabilitation. So completion of rehab in itself, any community service, even if it was court ordered, just the fact that you did it and you completed it, a counselor's letter, just other evidence of rehabilitation, and the fact that maybe the crime was a while ago and they haven't done anything since, and what they're doing to make sure that they don't do that. So there's various options you can look at. Okay. So really quickly, the filing process with USCIS. I think most people are pretty familiar with this, having filed the I-360, et cetera. So the first step, obviously, you fill out the I-485. The second step is collecting the supporting documentation. And if you go on the USCIS website where you would download a 485, they also give kind of a cheat sheet there as to what you should include. And it will also be in the instructions. So the instructions, read them very carefully and know that the instructions actually have force of law. So if something is in the instructions, it's pretty important. I did read the instructions about the medical exam. We have lots of questions about whether or not you actually need to submit that initially. And the instructions actually say no, because they know adjudication times are taking a really long time, and that the form is only good for a certain length of time. So you don't necessarily have to send it in with the 485. In fact, they'll usually send you a yellow letter if you don't, saying this is missing, but we'll ask you for it when we need it. Third step would be filling out the I-765, for example. When you file for adjustment under 245A, you are allowed to file a work permit to go along with it. So, and you can file those concurrently if you are filing at USCIS. The other next step would be to determine the filing fees and or complete a fee waiver request. And then you send it all to the Chicago lockbox. They have all the information as to where to send it. If you're sending it via the US Postal Service, or the direct address of the lockbox if you're sending it via FedEx or another courier service. Okay. So that is our presentation. I believe we now have about 10 minutes to answer some of the questions that have come through on the chat. I also wanted to point out that we do have 1.5 hours of Texas CILA credit for this presentation today, including 0.25 hours of ethics. And we have a survey, shouldn't say survey, a survey for you to fill out to get the CILA credit. And then we also have another survey for some feedback about this webinar and how it went. There's links here for reaching out to us for technical assistance, how to join our newsletter, and please don't forget to check out our website. We put so many resources and trainings like this. This webinar is recorded and it will be on our website. So, should we look at some questions?
Sure. So we have a lot of questions, and we've been trying to answer as many as possible. But we do have some here, so we can go through and answer some of these live. If we did answer your question and we didn't respond fully, you have some follow-up questions, just go ahead and type in another question and we'll try to get to it. Mm-hmm. So one of the questions here is, what if the client has not received their biometrics appointment notice and therefore has not completed their appointment by the date of the merits hearing? So in that circumstance, I would make sure that you followed all of those pre-order instructions and got the receipt notice from the Texas Service Center. If you have not done that part, then I would do it now to make sure that the biometrics appointment is triggered. If you did do that and your client just never received their appointment notice, then I would reach out to ICE, because they can request that USCIS issue a biometrics notice. And this is what USCIS recommends. Since there is that agreement between USCIS and ICE, their recommendation is that you go through ICE if you need a second biometrics appointment. If the USCIS defensive I-485 receipt reflects a fee payment, can the I-765 be submitted with that and no I-912 fee waiver application? So the I-765 doesn't have a separate fee if you file it with the I-485. So just with that I-485 receipt notice, you should be able to file the I-765 without having to file for a fee waiver or file a separate fee.
There's a question, is there a template we can use for motion to request adjudication by submission? We don't necessarily hold templates. I do know a couple of people who have tried it. We don't have an answer back yet as to whether or not it's been granted, but I would ask the community, either on the VERA, if you're a VERA member on the VERA listserv, you can ask on our various SIJ listservs as well, to see if anybody has one they'd be willing to share.
And similarly, we have another question about for a straightforward adjustment, has anybody ever filed a motion for summary judgment, which is similar to that motion by submission, either due to visa bulletin timing issues or not wanting to wait for the merits hearing to come up. And again, we have heard that some advocates or some attorneys are trying this method, but we haven't gotten feedback to how that's gone. But we do recommend it. The worst thing that can happen is that the judge denies your motion to rule on the submission or rule on the papers. And so you would just have to go to an in-person hearing.
One other thing to consider there is that in most cases, when you file a 485 with USCIS, it is not actually reviewable if it's denied. But if you're in immigration court and it is denied, it is appealable. And there are some BIA unpublished opinions about 485s in immigration court and discretion and all that kind of stuff. So that's a place to look.
We have another question here about any protocol or guidelines to negotiate with ICE. They used to call the office, but that doesn't seem to be an option anymore. So, persistence is our theme when it comes to those types of negotiations. You can, call, you can email, you can write them a letter, any way to get in touch. And hopefully with the change in administration, the ICE Council will be more open to negotiation. But even during the Trump administration, there are some ICE counsel who are willing to talk to attorneys. So trying to figure out through crowdsourcing who that is might just be the best option.
Another option, I know several kind of jurisdictions, OCC has like a email for the duty attorney. And if you can email that, especially if it's getting close to the when the merits would be, they will tell you generally who the attorney is going to be on the merits. The other thing is they don't always know that far in advance who the attorney on the merits is, for the merits hearing is going to be. Just FYI, but it's still, we here, just as a Houston example, we have one OCC counsel that generally seems to be in charge of filing motions to dismiss. So, if you do email a duty attorney, the duty attorney email address, they might be able to point you in the right direction.
We have another question, and this has been a frequent question about that 2005 ICE memo that speaks to not exercising prosecutorial discretion when there is an asylum application pending. And, it's not that the immigration judge couldn't dismiss the proceedings, or ICE couldn't move to dismiss the proceedings, but it is on there as, something to consider. So our recommendation would be to reach out to ICE to see what their position is. You just have to make sure you consider what happens to the asylum application at that point. Will it just remain open with the immigration court? Will the judge require you to withdraw it before dismissing the case? Those are just some things to consider when thinking that through. And it is something to bring up when you're talking to ICE. We have a question here about repeating the information regarding children under 14 and the EAD.
I think you're talking about the actual LPR cards, the green card.
Okay, so there is, if you look on the instructions for the I-90 and also just some general guidance on the USCIS website, it will let you know that children who are under 14 must then, and if they receive their green card, they must register at age 14. So this is likely because, they did not have the biometrics check complete. And so this is the time when USCIS would run a background check. And so you do have to file the I-90 at age 14 if you received your green card prior to that.
And now we have a question about, in Texas, the age of adulthood is 17 for crimes. If a child is between 17 and 18 and commits an inadmissible crime, does it count for USCIS? What matters is how the person was charged. If they are charged as an adult, so that happens a lot in Texas, kids that are 16 or 17 get charged as an adult, it is an inadmissible crime. It's only kind of an inadmissible crime or admissible crime if it's a delinquency, like, so they were actually, everything went through the juvenile delinquency system. Yeah, so unfortunately.
We have a question here about where the definition of crime can be found.
So there's not really a definition of crime per se. It's a definition of crime involving moral turpitude. And there isn't a definition in the statute, but there are some definitions in case law, the most recent of which is the matter of Silva Trevino, which is 26 INN December 826, which came out of the BIA in 2016. That's where you get a really nice, concise definition of what crime involving moral turpitude is. And so in order to really figure out if a crime, if a behavior that somebody was charged with is a crime involving moral turpitude, would be to go then through the categorical analysis or categorical approach analysis like I suggested.
We have another question here about a client who has an unfiled NTA. Would we recommend going ahead and filing with USCIS, or is there a risk that DHS will then file the NTA? Our recommendation would be to reach out to ICE counsel to see what they intend to do with the NTA. Many times it just got lost in the shuffle, and there really is no reason to file it with the immigration court, especially if you let them know that the child has an I-360 approved and you're trying to move forward with adjustment. We have heard sometimes that USCIS wants to make sure that the NTA won't be filed. So if they do ask that question, you can then let them know that you did discuss it with ICE before you filed with USCIS.
We've had a couple questions about kind of the whole false papers thing when people use somebody else's social security number. It is, so interestingly, that's not necessarily a misrepresentation for inadmissibility purposes or for immigration purposes, because that has to be a misrepresentation to get an immigration benefit. And working is not an immigration benefit. So that's where it goes towards kind of discretion. I mean, really, that's a crime. So it's kind of, how do you answer that question? Does it fit within those elements of the crime? So just kind of something to think about and analyze. Okay, we're at 3:32.
Okay, we have a lot more questions to answer. We're sorry that we didn't get to answer all of the questions. We realize, we don't want to take up people's time, so we can hang out and answer a few more questions, but feel free to jump off. Thank you so much for joining us. We hope that this was a helpful presentation, and if we didn't get to your question, if you need to hop off, please feel free to email us at CILA@abacila.org, or you can go to our website and submit a question through our technical assistance portal.
So there's been a couple questions also about when somebody has a removal order and the waiver. So the deal with getting a waiver for a removal order is that that waiver only comes into effect when you leave the country. So you can't just submit a 485 and submit a 212 waiver for a removal order. It's not how it works. You must take that 212 outside the United States and get a consular officer to kind of give you your immigrant visa that way. So unfortunately, it doesn't, you can't, if they had a removal order, if you don't want them to leave the country, you've got to reopen it with the immigration court.
We had a question about when you file the I-601 waiver. And so you file the I-601 waiver when you want to waive a ground of inadmissibility. So that's the only time. If your client has one of the grounds of inadmissibility that can be waived, then that's when you file it.
And unlike many other times when you're filing an I-601 for a waiver, in this instance, you can file it at the same time or concurrently with the 485. We had a lot of questions about motions to reopen.
So any strategy recommendations for motions to reopen in terms of arguments? You know, there are specific grounds for reopening different types of orders of removal. There's, you know, there's certain things that you must prove if it's an absentia order versus a final order. And so those things are you know, generally complicated, but, and we do have some more resources on that. And I'll let Vicki speak to that in a minute. What I will say is that if you have an in absentia order, but you don't have, but you're over the time limits or one of the provisions for reopening doesn't apply in your case, then I would try a joint motion to reopen. So you could reach out to ICE, let them know that you have an approved I-360 and ask if they will join in a motion to reopen.
So we do have some resources. If you are a VERA-funded organization, they should be on CILA's portion of it's not called Huddle anymore, SharePoint. And so you can try and look those up. We did, there is a practice advisory that we did joint with Clinic. It was geared towards MPP, but it's very similar, a lot of removal order stuff. Yeah, so you can find it there. If somebody has that direct question about that, you can send us a TA question about it, and we can try and get you a copy of that. Yes, I see a question. What is an OBIM FOIA? So this is the kind of FOIA that you can do. It's the Office of Biometric Identity. I can't remember what the A stands for. So it's, if you go on to DHS, actually, it'll tell you all the different types of FOIAs you can do to DHS. And OBIM is where you, along with your request, you send in an FBI fingerprint card that has been done. You know, a lot of times police stations will do them and stuff like that, although many of our clients don't want to go into a police station. So there are other places around town that you can pay for them to do your fingerprints. So something to think about there.
We have a question about whether there's a procedural distinction between a motion to dismiss and a motion to terminate. And yes, according to the regulations, you know, the motion to dismiss is something that ICE can do procedurally when they want to exercise prosecutorial discretion. There is a provision that allows judges to terminate proceedings, to allow applicants or to allow respondents to move forward with a citizenship application. That's in the regulations on the EOIR side. And then, you know, if you are arguing that DHS did not meet their burden of for removing your client, then you can also seek a motion to terminate proceedings because DHS didn't meet their burden. So that would be a motion to terminate. So, you know, just to kind of keep track things with the regulations, this is why, you know, we try to use the these try to make the distinction.
Somebody was asking, you know, if you manage to get a removal order reopened, like an in absentia one or something like that, do you still need a waiver? And the answer is no, because when you reopen that removal, when you ask for that to be reopened, you're canceling out the removal order. So they no longer have a removal order. And so no, you don't need a waiver for that. I do know, in case some of you are wondering, I do know that there was an issue with the CILA survey, and I apologize about that. It does, I think it has the wrong CILA number. So I think it's been corrected or will be corrected shortly. So I'll send out an email after this to everybody with the survey and the correct CILA number.
There's a question here on whether we recommend submitting letters of support, evidence of equities in a typical I-45 to USCIS. And I would say generally no. That really only comes into play if there are some negative equities that might outweigh the positive. So otherwise, you should be, USCIS or EYR should exercise discretion favorably if there's nothing to sort of combat that determination.
Mm-hmm.
We're getting up to 10 minutes
Yeah.
already, so I think we'll wrap it up here. Like I said, if we didn't get to your question, please feel free to get in touch with us through the website or by emailing us directly.
Yep.
Thanks so much.
Thank you, guys.